Evening, everyone, and thank you for joining us for our January 2024 Rise at Night. I am Lisa Morgan, a kindergarten teacher, and I am proud to currently serve as president of the Georgia Association of Educators. Um, Thank you for being here this evening. Our topic this evening is teacher contracts, and we're doing it in January this year because last year we had members tell us that they received their contracts in early February. So we moved it to the end of January, and we do know that there is at least one district that has already issued contracts for next year, mid-January. So hope this information will help you. And as we go along, if you have questions, if you do want to put them in the chat, we can do it that way. Or if you raise your hand, I'll try to keep an eye out and let Mike know that there are questions. But at this time, I will turn us over to our Director of Legal Services, Mike Magano.
Okay. Thank you, Lisa. Let me right. There, is that up, Lisa?
Yes, perfect.
Okay. All right, thank you. See how this goes. So tonight we're going to be reviewing the basics of educator contracts, how they're made, what obligations and responsibilities that both sides have in this commitment. And then we're going to look at ways to get out of a contract as well. So these are the most frequently asked questions that I've encountered over the years. Please don't be shy if I need to repeat something or clarify something as we go along. So I want to start though with just a quick review of why a GA Legal Services program is better than competitors. Our employment liability protections are actually, they provide greater liability protections. It goes up to $3 million aggregate in any program year in the event that you're sued. And there are multiple counts that can, add up to quite a sum of money. And then of course you've got your lawyer's fees that could go all the way up to $9 million. I don't think that's ever really going to happen, but the coverage is there and it is better than the competition. Now, employment liability protection, what we should understand is that protects us when we are sued by, say, a parent on behalf of a student who is injured at school or is alleging they didn't receive their free appropriate public education under federal and state special education law. We only see half a dozen of those cases, certainly less than 10 per year. So we don't want to ever be sued, but the fact is the lawsuits are a small, very small number of the number of cases that we come into legal services. It's the second part, the employment and certification defense, that is the bulk of our program through the NEA. And the big advantage for GA members is that first bullet is we have no predetermined cap on the amount of legal fees or costs that we expend either in defense of a member's employment or their certificate, or if we file an affirmative lawsuit on behalf of a member, there's no predetermined cap. Other organizations will cap you, and once you hit the cap, you gotta pay out of pocket. So that's that's just not the NEA GA program at all. It provides greater value for your dues dollar. And I always want to pause just to reflect just a moment. I know history is not dates, but these are, important dates that I like to look back and just reflect for a moment on our founders, particularly the GT and EA folks that were formerly enslaved. And as you see the dates there, 1878 is when they called their first statewide meeting. And for you amateur historians out there, you'll know that's when Reconstruction ended and the federal government pulled back, providing any protection uh, for our Black citizens, and so that's not a coincidence. 1878. Then you go forward. Of course, we have all the Jim Crow era, and then by 1954, the Brown versus Board of Education came along after years of litigation, and of course, everyone knows that Brown stands for the proposition that separate but equal is inherently unequal. And that set off, an avalanche of desegregation movement in our country, as well as the 1960s civil rights era. One of the lessons, I'm just going to pause on that, under the Brown decision, it's we're still in the process of integration, and we're still in the process of providing educational equity for those who have generational debts, given that from where they started the race. And what I've reflected on is that, from my perspective, I have to embrace race. I don't want to shy away from it. And for me personally, what that means is, to the extent I'm not doing something as an individual to oppose racism or oppose structural racism, then I'm really part of the problem, and I just need to get out of the way. And then of course we had the merger in 1970. That's when the court gave its blessing. That was a very, very, very formal process that created the new GAE. And if we look forward to the last time we addressed racial issues inside GAE was 2022, when the Representative Assembly removed the ethnic minority guarantee language from the mergers and replaced it with more modern language to affirm our commitment to diversity and inclusion at all levels. I can't see the screen, but it should be equity, diversity, and inclusion at all levels. So that maintains our commitment to the principles of the merger on paper. So one more preliminary before we sort of get into the nuts and bolts of contracts is that Georgia is a very unique state. There are three models of educational delivery in Georgia. I don't think any other state has this. You have an ability to waive education laws, including, as far as I know, we haven't challenged all of the contract statutes in court, but you can waive pretty much any education law, your Fair Dismissal Act, your class size, your certification requirements. And the bargain is, if you eliminate state law, which is viewed as red tape that is weighing down on the backs of school systems and students, that if you waive these laws, student achievement will soar, go through the roof. But there is absolutely no data to support that proposition. So as we go through this, and as you go through your professional daily activities and questions come up, you need to remind yourself what model of school, what model does my school system follow? A traditional model, where we don't waive any laws. We're going to follow class size, for example, and the state salary schedule and the Fair Dismissal Act. Or am I employed by a strategic waiver school system where the school board gets to pick and choose which of the education laws that they wish to waive? And the third model is a charter school system, which effectively waives strict compliance with all of Title 20, except with a few exceptions. They can't waive special education law. Surprise, surprise, they can't waive TEKS. And of course, they can't waive we wish they would. They can't waive the code of ethics. But keep this in mind as we roll along tonight, and as we move along in your professional lives at school. Who employs me? What do they waive? What do they not waive? And keep in mind, if they waive something that's doesn't make any educational sense, like class size and certification, the local board can unwaive it, right? They can unwaive it. They can get a petition together if we put enough political pressure on them to reinstate the class size rules that have been there for generation, or certification. The list is limitless, but it's really up to us as political organizers to pressure local school boards as well as the General Assembly to address harmful waivers. So I thought it'd be a good idea, before we get into what's a contract, I just like to put a slide in there. Well, what isn't a contract? What isn't? What isn't it? Well, Georgia belongs to a over 200-year-old tradition dating back to the early colonial days, really, called the at-will employment doctrine, and it has not been modified in all that time since the colonial days. And there's this one decision that finally went up to the Georgia Supreme Court in 1853, as you can see, which put in the common law or court-made law as to what an at-will employment relationship is. And it basically is, if I perform some services for Lisa and she pays me a sum of money, I mean, that's well and good, but we don't have a contractual relationship. Either party can terminate the relationship at any time for a good reason, a bad reason, or no reason at all. And that's been on the books since, well, before 1853, but in 1853, the Georgia Supreme Court put that in their decision, and it hasn't changed since. So yes, we do live in 1853, as some of you know. There's a good article. I just include that on there if you want to take a picture by this professor that wrote an article about exploding the original myth regarding employment at will. For what it's worth, you can download that, Google it, download it, and get some more knowledge on at-will employment in Georgia. So, well, wait, I want to go back, because important to remind people, even though you're in employment at will, doesn't mean you have no rights. There are no rights under state law, but at-will employees are covered by federal law. Okay, I just want to run down the list, and then I can have another presentation, completely devoted to at-will employment rights and responsibilities. But you would be covered by, say, for example, the Fair Labor Standards Act, meaning you got to be paid minimum wage and overtime. You are covered by the Title VII federal anti-discrimination law that protects you from things like race discrimination, sex discrimination, national origin, and religious discrimination. You're also covered by the Federal Age Discrimination and Employment Act, the Americans with Disabilities Act, as well as Section 504 of the Federal Rehabilitation Act. And those two pieces come in handy over the years. If you are in a special needs setting and you are advocating on behalf of a special needs student who may not be receiving appropriate services, and if you're retaliated against, there are actually anti-retaliation protections in both the Americans with Disabilities Act and in Section 504. So those laws are good if you have a disability. The employer has to provide you accommodations. But on the special education context, there are good anti-retaliation protections when we are advocating on behalf of a special needs child. And then the last federal law I would just simply mention tonight, and like I say, another presentation, I can spend more time on it, is the Family and Medical Leave Act, which protects your job to care for a serious health condition of your own or an immediate family member, and to care for a newborn baby or the adoption of a baby as well. And I can spend more time on that in another presentation. So these are the three basic common law elements of a contract. And in law school, you spend a whole year diving into what is an offer, what's acceptance, and what's consideration. Those are the basics. The other basic is that a contract has to be enforceable. So those are the basics, and we'll look in a couple of slides as to what those entail in teacher contracts. And then lastly, in addition to the common law elements, common law is the decisional law generated by courts, like we saw in that 1853 at-will employment case. That was referred to common law. And then legislatures come along and they codify the common law. And so the contract statute in Georgia, if you're interested, is Title 13. And you can look that up and get some more knowledge and information about the basics of private contracts in Georgia. And what's special about teacher contracts is that there is a whole other statute in the education code in Title 20 that the legislature says Title 13 is great for private contracts, but these are public school teachers, and we're going to regulate public school teachers' contracts in Title 20, and we'll take a look at what that statute is about. Well, and here it is. Contracts are governed by 20-2-211. And I need to slow down? No. Okay, so one of the elements of a contract is the offer. And an offer, basically is when you get the written agreement either handed to you or it's in the your mailbox at school. But importantly, in this particular statute, there's language in there that's saying that a letter of intent is not a valid offer or even a valid contract. And when I began my journey at GAE years ago, that language was not there. And some of the early fights we had with school districts, it came about over really silly stuff where, Mike would check a box on an intent to return form saying, he's going to return for next year. They gave this intent to reform form to me, January, February, or March. And they tried to enforce that as a valid contract. And, after, numerous silly fights over this, GAE took the lead and got the General Assembly to put in the contract statute that a letter of intent is not valid, not a valid offer, and it's not a valid contract. But you should thank GAE for getting that particular language in there, And that solved the problem. We don't have any more disagreements, any more fights over, intent to return form. Now, here's something that you need to keep aware of. Now, contract review period. So I get my contract today. Now, under Title 20, it says I get 10 days to review my contract. I get 10 days. It's in Title 20, right? You got to know, is that waived? Did my school board waive my right to a 10-day contract review period? And yes, they can waive that. They can waive that. So once you get your contract, you should ask them, how much time do I have to review it? And contracts are often accompanied with a cover letter, and the cover letter should state how many days you have to review and return it. So keep that in mind. And I know plenty of folks over the years that do not like to be pressured to sign the contract because, in this area, there's, we have few rights and we fought so hard to get them that if I have 10 days to review a contract, I'm going to take my 10 days. And you're just going to have to wait, give me some respect and just, I'll return it in 10 days. Why? It's my right.
Mike,
Yep.
I actually just looked that up, and there are 13 districts that have waived that particular law. I'll try to figure out who they are, and while you're doing the rest of it, maybe I'll be able to put those districts in the chat. But we do have a question in the chat. So it says, how about the people who have come from other countries on international teacher exchange contracts? What kind of rights do they have?
Off the top of my head, I'd like to see the contract before I really said anything. I don't want to go too far out there, but I know of situations. In DeKalb years ago, they were bringing in teachers from foreign countries, but they were employed by a placement agency. And they were in the classroom, and the district allowed these teachers from foreign countries to deliver classroom instruction, but they were employees of the private placement agency. Now, I don't know if the person who's asking the question, if that's their situation, but if you want to email me that, the contract with a few more, specifics, I'm happy to take a look at that for you.
Okay. And I will put your email address in the chat so they will have it.
So the second element, basic element of the contract is acceptance. So the important thing is, so when I sign the contract, that's evidence of my present intent to return. And that's going to be, that's what that means legally. That's my intent to return, and that's going to be the evidence. As part of my bargain, I intend to fulfill and honor all of the terms and conditions of the contract. That's straightforward. And then, of course, the superintendent's signature is also evidence of offering making an official offer. Contracts usually come with the superintendent's signature, maybe not everywhere. And then the last piece is, in my view, in the view of GA lawyers, is that it has to be, even though I've signed the document, it has to go to the board for approval. It has to go through a process, and approved. Because maybe I didn't sign the contract, I turned down the offer. Well, that's going to have to go to the board as I'm no longer, I'm not returning. And this idea that an employment decision has to go to the board for final approval can be true for a resignation as well. And there are some situations where a person feels pressured to resign. And the first question we would ask, well, has the board approved your resignation? And if the answer is yes, then we're in deep water. Really nothing we can really do if the board's approved it. But if the board hasn't approved the resignation, then we're going to have to try to persuade them to rescind the resignation. And that can be successful and it might not, but we try. And then often in those situations, if they do agree to rescind the resignation, they then normally have to provide a due process hearing, a fair hearing with lawyers on both sides, subpoenas and witness testimony. And we can, if nothing else, negotiate a fairer exit from the school system. Maybe it's a letter of reference. Maybe it's not contesting unemployment compensation, those types of things. So rescission of a resignation is only final if the board approves it. Now we're going to see these dates, I think in a few different places, but if you're taking camera shots, you should probably, this is one, that's why I made a special slide. So there's two important dates in Georgia. Contracts have to be offered to educators by May 15th. If they're not offered by May 15th, then it's like by magic, your contract is automatically renewed by operation of law. Even though you didn't get the written paper, your current contract is renewed. Now, you then have, if you have a written agreement that you sign, say, in January, which is happening, you have until, under the state law, you have until June 1 to resign. Then the language, I put it in quotes, not later than June 1st. And we'll get into, down the road, well, did they waive that June 1 date? I mean, that's, these waivers are really, really stripping away important rights that you have. And we'll see, I think in a few slides, some of the ins and outs, some of the problems that are posed by waiving contract rights that you've had on the books for decades and decades, and they're just gone with the stroke of a pen. So obviously always read your contract. And but later in the presentation, we talk about liquidated damages, but the questions keep coming up. Well, there's a, if I want to resign and leave from this contract, I have to pay them a sum of money. And there's no state law that mandates liquidated damages. Districts are all over the place on liquidated damages in terms of the amount that they're going to charge you for getting out of your contract. And sometimes they charge more for administrators than classroom educators to get out of administrator contracts. So they're all over the place. The second bullet, that's, contracts in Fulton County have come out in January. But the important thing for us to realize, there's no law that says they can't do it. And I facetiously or sarcastically put up there, well, if they want to put a tender contract in Christmas, I suppose they could. But the important thing is people at the State General Assembly and your locally elected school boards aren't defining when they are required to tender contracts, right? There could be a date, contracts shall be tendered, not before, not before March 1, something. But there's nothing in state law or local board policies anywhere in the state that I have seen that limits how early contracts can come out or be offered. It states, the state law also states that contracts have to be complete in all terms and conditions, including the amount of compensation. And we'll see in a few slides a really great Georgia Court of Appeals decision on that point. And it is a GA funded litigation that we did on behalf of GA member John Tibbetts. Gosh, and I can't think of the county he was in.
Worth.
Say again.
Worth.
That's it. That's it. Worth County. And I'll talk a little bit about that case in a few slides. Oh, and the state statute. Here's another opportunity for us to lobby the legislature. The law governing teacher contracts doesn't require the contracts to state the specific position or school location in your contract. And I imagine the reason they don't want to do it because it gives them more flexibility to transfer you involuntarily to a different school, a different grade level, what have you. So they want the maximum flexibility under Georgia law to move you and transfer you. So therefore, that to me, that explains why they don't put that in writing yet. So how do I get out of my contract? Well, there's two methods. The resignation is one method, and the release is another. And what you have to keep in mind is a resignation is a unilateral act. And what that means is I can resign anytime and walk out. I can walk out of the classroom and never to return. That's my right to do so. But keep in mind, if I do that, there's more than certainly going to be repercussions, particularly with my teaching certificate. I can be charged with a breach of contract, and abandoning my classroom and exposing the students to safety. Just abandoning the classroom is never a good idea. But you don't want to abandon your classroom. So, but a resignation is definitely an option. It's an option, but you have to be real careful and under what circumstances that you're going to be going that route. The other route, which is it's a safer route, but it also comes with its own limitations, and that is the release. So a release is a bilateral act. I'm requesting to get released from my contract, but I don't have a right to it. Unlike a resignation, I see a resignation as something I have a right to, but not a release. The release is up to the district of whether or not they're going to grant me the release to get out of my contract. And we'll see in a slide or two that that's just not very easy sometimes. What they'll often do, I'm looking to see if we have a slide on this, but they'll say, sure, Mike, we'll release you as soon as we find a suitable replacement for you. Well, what if I teach in Worth County and I teach, physics? How easy is it going to be to replace me? Probably not very easy. So there are some real limitations with getting the release, and I think timing is always an issue. For example, if I signed my contract for 24-25 today, and in a couple of weeks, I got a better paying job, closer to my house, closer to childcare for my family, all those things, I stand a better chance of getting a release under those circumstances versus if I I found that new job with the childcare closer to home, closer to June 1st, because the rule of thumb is it's much easier to get a release from contract or resign prior to June 1st. After June 1st, it gets tricky and sticky.
Mike, we have a question.
Okay.
Lisa?
Okay, yes, thank you. I wanted to find out for special education teachers. I know that is I've been teaching for 30 years and it's always been a teacher shortage area and it's a high demand position. So if a teacher wanted to get out of a special education contract, how hard would that be knowing that it is a teacher shortage area? Thank
Yeah.
you.
Well, it usually is going to involve what other facts and circumstances are surround my request for a release. You know, is it my poor health, my parents' poor health? Um, I mean, you know, anxiety, you know, depression. I've seen, you know, medical conditions. Um, it really is going to depend on the specific circumstances of why I want to release. It often is, if it's just for a better paying job, it's generally not going to cut it. We'll see the professional standards commissions have a release of contract guidelines, and they say if you get a promotion in the field of education, they will not cite you for a breach of contract or abandonment of contract. But to your point, it is harder to find the suitable replacement. That's the phrase I hear over and over again. And I'm sure people on this Zoom have heard it too. What's a suitable replacement and how long can they search for the suitable replacement? And there's nothing specific in law that says 2 weeks, 3 weeks, a month, none of those things. But occasionally we do find favorable facts surrounding getting a release or a resignation from districts. And we'll see in a couple slides, I think, successful lawsuits that GA has filed over the years. But we have to be very, I guess, picky. We don't want to set bad law. And so far, we have done this successfully twice. And we are always looking for favorable set of facts and circumstances to bring another suit, because, you know, lawsuits are a last resort. They're a last resort, but the General Assembly, you know, on these issues, they're not listening to your voices, and your local boards of education are not listening either. I mean, if they're out there and they've waived all your fair dismissal, your class size, you know, we've got some real organizing work to do to get them to recognize, I think, number one, respect and how valuable you are, and that you can't be treated almost as if you're in an involuntary servitude situation, which is my analogy to teacher contracts and paying the liquidated damages. Servitude is, you know, I'm in debt to my master, and he will be my master until I work off the debt. Well, it seems to me the liquidated damages in teacher contracts are to me have very, very substantially similar features to it. And we're not shy about saying that in our lawsuits and the briefs that we file. You know, sometimes you know, enough is enough. But a lawsuit basically only is like a rifle shot. It's not as good as getting a state law change or your local board of education policies to enshrine that in local policy, which has the effect of law. So a lot of the enforcement of contracts comes from teacher certification rules. Now, interesting point there is, let's say you you leave your job, you couldn't wait for the release for whatever reason. Maybe you did get a job in another district. Maybe you did. The school district has always had the option to file a lawsuit against the educator for, that liquidated damages sum. They have always had that ability. And in my experience at GAE, that it's just never happened. Never happened, not gonna happen. They're not gonna waste money on a small claims action when the real dirty work can be done by the Professional Standards Commission. So if I leave my contract without a release, your local school district can file a complaint against me for breach of contract. And if you can study the slide and see what the definition of breach of contract is, they will do it. They will do it. The bullet there about the PSC will not sanction a certificate of resignation is submitted prior to June 1. Here's something you should know. Last year, the PSC said they will not sanction a certificate if resignation is submitted prior to June 15. In other words, the PSC gave the thousands and thousands of educators an additional 2 weeks to submit a resignation without penalty. Your guess is as good as mine, but they have limited your right to a resignation. They've taken away those 2 weeks. And I suppose there was some discussion at the meeting where it was done about I don't know, a teacher shortage, and they all fall in line. Rather than building up the profession, they want to limit and narrow your rights, and they approach teacher retention in a very backward way that doesn't improve the profession. It's more of a punitive approach to keeping the labor force in place. That's kind of what my observation. They want to keep you in place, keep you quiet, do your job, and make those students, make the student success go up. We'll see in a minute. I think it's the next slide. What a partial list of the breach of contract guidelines are. So, you can read the slide to yourself. But I like, the second one tells you a lot of where they're coming from. An administrator who's offering a contract to educators after June 1st who are currently under a contract with another district may have their license sanctioned if the educator does not have a release. Well, to me, that's sort of like codifying collusion. I'm not going to, if I work in DeKalb and I have a better paying job closer to home in Gwinnett, right next door, even before this was in their guidelines, there was always the unwritten understanding that Gwinnett is not going to steal DeKalb's teachers, and DeKalb's not going to steal Gwinnett's teachers. But there it is. There's a warning in black and white to threatening administrators for taking on employees employed that are under a contract in a different district without a release. Now remember, I can resign, right? I can resign and take this other job. Resignation is a unilateral act, and I can take this other contract. But they have made the rules so onerous and oppressive that they're telling us Mike's resignation has no validity. He's got to have a release from the superintendent approved by the board before he can take that job closer to home, closer to my childcare, better for my family. They just made things really, really difficult. Now, of course, the PSC is going to say if you pay the liquidated damages to the school district, you're good to go and they won't sanction you. So that's an enticement or an incentive for the PSC working in concert with local districts. Go ahead, pay the liquidated damages and we won't sanction your license. Now, one last thing I'd say about these guidelines is I was getting ready for this meeting. I looked at the guidelines for breach of contract that were first published in 2018. And in the 2018 edition, there was that last bullet there that said, we will not sanction an educator if the school system failed to provide any assistance to the educator to be successful in the classroom. That would not be a breach of contract. And when I looked at the latest version of the breach of contract guidelines that went into effect August of last year, they took that out. Again, how can you uplift the profession, improve the profession, if you're going to, I guess, acknowledge that you have poor administrators who aren't providing assistance and have made the working conditions so intolerable that, my mental health is, going down the drain, or I'm in a challenged community, high poverty, high crime, high violence. The kids, students are coming in there threatening to kill me, or have my older brothers who are in a bona fide gang, and they know where you live. They know where you live, and they're gonna hurt you. Those are real examples, and of course, administration doesn't take that stuff seriously. And in other years, we were able to document all of the threats and the, just the poor working conditions in some of these challenged communities. And we were able to convince the PSC not to sanction these educators because they were in fear of their life. And the school district was failing to provide assistance in terms of the discipline policies and enforcing student discipline. Well, really, it just, breaks my heart now, here we are, the PSC took that out, and I don't know how, but we got to change that and have them put that back in, and be serious about supporting you, not just making the code of ethics a punitive weapon. So I alluded to these liquidated damages cases. First one we did was against DeKalb County. And on behalf of two of our members, these two ladies, they resigned before June 1st. This is about as good a facts as you're going to get. They resigned before June 1st, and DeKalb took the $750 out of their final paycheck. And it's just as simple as that. And we ended up settling for a total of $110,000 of court-administered reimbursement for every educator that had $750 deducted from their final paycheck. And as far as I know, President Morgan can affirm, they have not put that liquidated damages clause in their contracts in DeKalb. Now, other districts continue to do it. We also got $50,000 reimbursement of attorney's fees in that case. The other one that we did, sometimes people are, we sued. I think that the interesting thing about suing Griffin Spalding on behalf of Nikita Jones and Cheryl Clark, Cheryl Clark got a promotion in another district. They still took her money. Nikita Jones has had a disabled child, and the doctor basically directed Miss Jones to relocate closer to their home and the child's school due to the medical condition, and they took her $750. But so we settled it. But look at that second bullet. So the school district said we had declared war on them by filing a lawsuit, and they said our lawsuit was not professional, and they were threatening, and the orders were there from their lawyer to take away our payroll deduction slot as a method to collect dues. Well, if you've been around enough to know, you know that's unconstitutional. They're penalizing our members based on association with GAE. And so within a couple of weeks, the NEA came in, and we had an NEA staff attorney help us with this First Amendment lawsuit, and we filed it. And within weeks, they completely backed off and settled, and they never did take away our payroll deduction from us. But that's also a lesson, it seems to me, as we go about our local organizing activities, and we do it, the right way. I'm speaking as an association member from my local board about matters of public concern that affect all teachers and all taxpayers in Lumpkin County, wherever I'm at. We have First Amendment protections there, and we have the resources to file First Amendment lawsuits if we are advocating, just as this lawsuit was. It was an advocacy piece, filing a lawsuit on behalf of a couple of members. They just said it was not professional and wanted to take away payroll deduction. People shouldn't just know you have an organization that's going to stand behind you. And we may not be able to stop all the retaliation, but many of these districts are pretty blatant about it, declaring war and not professional. Hey, that was in emails. We got the emails, and so we need to think about that, and just know that GA has your back when we go out to recruit and advocate to take away some of these harmful waivers. Well, the last litigation in the contract area that GA did was back in 1990, and it really established that teacher contract has a 6-year statute of limitations. Excuse me. So what that means is, this still comes up today. So let's say I transfer in from another school district, and 2-3 years roll by, and my current school district did not place me appropriately or correctly on the salary schedule. So I've been underpaid for the last 2, 3, 4 years. And I go to them and they go, oh, we agree, Mike, but you know what? We can only go back this current contract. The other contracts and the books are closed on those first years that you were employed here. This case will take care of that response, because we have a valid legal claim to go back to previous contract years, and it just will blow the argument out of the water that you can't go back to previous contract years to collect the salary that I'm entitled to. And the excuse that the books are closed will not hold water either, thanks to that case that GAE funded back in 1990 against Muskogee County. So that's what I had to say this evening about teacher contracts. And I mean, I hope some things were new and some things were a refresher. If you have questions, you can ask them now or shoot me an email.
Mike, we
happy
do
to
have a
address-
question. It's in the chat, so I'll read it. Is it legal for the district to provide courses for gifted certification free of charge under the condition that educators enrolled in the courses have to sign an agreement stating they will not leave the district within a certain amount of time after getting the certification? And if the educator signs an agreement, is it enforceable if the educator wants to leave the district?
Off the top of my head, the answer is yes to both questions. Remember, once you sign an agreement, that's my evidence of my intent to honor the agreement. So, there may be things that pop up, other factors why I have to leave, that might mitigate the damage. But once you sign the agreement, it's telling the other party that, hey, I'm going to honor this and fulfill all the terms and conditions.
Okay. Thank you. I do not see any other questions in the chat.
I have a question just for clarification, if possible.
Certainly, go ahead.
Okay. So I just want to go back to you got your contract, you only have 10 days to sign. No other districts have offered contracts, but I know you were saying to resign or ask to be released. And I just wanted clarification, which is the better version? If it's before June 1st, so let's say before June 1st, let's say even before spring break. Is it better to resign or ask to be released?
Oh, to me, it's almost, it's probably better to seek a release. That's just
Okay.
been.
Okay, because the contract you mentioned earlier that you looked at was the contract I sent over.
Oh, yeah,
Fulton.
yeah,
From Fulton.
yeah.
Okay, so you're saying it's better to ask for a release. Okay.
Yep.
Okay, okay, thank you.
You're welcome.
Okay, thank you.
And-
Thank you all for participating this evening. And we will have another Rights at Night next month. We do these on the last Tuesday of the month. So be sure and sign up for that session as well. Everyone have a great rest of your evening, a great rest of your school week. And thank you for being a member of GAE.